How's it going? My name is Attorney Sherrod Seward, and I'm part of the intake lead team at Sherrod Sports Visas and Innovative Immigration Law, where we do a lot of cool things with P and O visas and all types of sports. And today we're talking about probably my favorite sport right now, which is football, American football, which there are more and more international athletes participating in nowadays. And I kind of wanted to shed some light on some of the issues that are surrounding international foreign football players trying to get into the NFL and some that are already there. We have done visas for current NFL players, prospective NFL players, and NFL players after they are done with their career. And we've had a lot of success. The things that is that there's some, the NFL doesn't do a lot of creative things. Teams do. Is at the team level. They do not do a lot of creative things when it comes to the structure of petitions, which creates a major obvious problem. Is that typically teams will always want to apply for a P1 visa as the team for the players on their roster. The problem is a lot of the foreign players do not actually make rosters or they get cut. When that happens, they have 30 days to switch to a new visa category or leave the country. And a lot of times, unfortunately, they have to leave the country. And another thing is, if it's during the middle of the season, it's unlikely that a team would want to pick up a player contract on someone that can't play for 2 weeks while they wait for their visa to get adjudicated. For that reason, for about 3 to 4 years now, we've been advocating and been successful with applying for visas for athletes, football players, through their agencies or third parties. So that way, the visa stays intact, whether or not the player is on an active roster, and the player can use the same visa to play on different teams. We've done that twice. One situation is where we had a kicker that was a good at the NCAA level, and we got him an O1A visa, and he was able to play for 3 different teams on that A1 visa before eventually transferring to getting an EB1A green card. Now, another situation we had was with a player that was cut from one team, and we were able to place a visa for him within a couple of days for him to be available for the practice squad of another team without holding a roster spot. The problem comes in when it comes to the consultation letter and the contracts with the team. The way that we structure the petitions is that there's an agent or a third party that's direct in navigating, or even the party themselves navigating where they will play. In addition, we say that there's no consultation letter available, which is something that is usually required in sports that have a labor union, such as the MLS, NBA. They want to get a letter from the Players Association that says that it's okay for this player to participate. The problem is the Players Association in an NFL will not do that for players that are not currently under a roster. So our stance is we do not need them to give a consultation letter. That we can give them to do 2 things. One, to just say that we do not offer letters for players that are not under contract, or 2, just give a letter of no objection, which just says we don't have any problem with the player getting a P1 visa. The problem comes in is when the NFL team or Players Association might not get the concept and they say, yes, we want a consultation letter that's petitioned for by this entity or the team. Then that's going to create problems that are much worse than if they just said nothing and just let us make our requests and ignored us. It's much worse. The other thing that comes in with USCIS having bogus adjudications is they look at the contract of the player and say, like, well, it looks like they're saying they have to play for this team, which counteracts their decision of just choosing where they play, which of course is, I don't know, just pretty asinine. Because obviously the player gets to choose which team that he's getting ready to play for. A player can then opt to not play for that team or sit out a year. There's a lot of ways to say how they will navigate where they go. But the USCIS decision on one of our cases was pretty much like, no, it's the team that navigates and directs where they will play, not the player that ultimately decides what team they will play on. So for that reason, we are most often advocating that players get an O1 visa, just because there's a lot more leeway to play with the schedule and itinerary of what you'll be doing rather than a P1. Because if you are on a P1, then you will be required to show that you have competitions in mind that will require the participation of internationally recognized athletes. Second is you're more privy and prone to being boxed in by the NFL Players Association if we get into an issue about the consultation letter. That's only happened once where it's been a problem. Most of the time we're getting able to get around it, but it did come up once and it's got our attention. The next thing is when you're an O visa, you're in a category that's much better than the P1 because you can do other things just rather than just compete. The problem comes in sometimes if you come to teams that are unfamiliar with exotic structures for doing the visa, they'll push back and want to change the visa from an O1 to a P1, which is one, a much less prestigious visa to be on with more restrictions. And then second is if they cut that player, now we have to extra work to do to put them back in that other status. So if they just let the O1 rock, there would be no problem with signing them on that O visa and going about this business. And if something happens where the relationship's cut short, then there would be no problem just letting the player go and he still has his visa intact to do other things. But if they go and file a P1 that changes his status from O1 to P1 or changes his own P1 to the team's to P1, when that's reduced, now the player has to either leave the country to come back on his previous approval, or we have to file another petition to reinstate that previous status. So it's one of those things that could be avoided with more education and talking to the teams about transparency and how this works, which is something that we'll continue to do to give more opportunities for foreign national football players to enjoy the same opportunities and speed and access to teams as foreign-born players. And I think we could all say that we're enjoying the diversity that's in football, getting a lot of different flavors, a lot of different type of athletes, and the teams are appreciating those extra set of skill sets that they're getting as well to compete for the Super Bowl. And with that being said, I hope to continue doing updates on the work we're doing in football and talk to you soon. Peace.